case is not a criminal trial. The ICJ will deliver an opinion on the genocide allegation, but it's being keenly watched internationally. Established in 1945, the ICJ is the United Nations' highest legal body, ruling on disputes between countries as well as giving advisory opinions. The 1948 Genocide Convention, which has been ratified by 153 countries, including South Africa and Israel, defines genocide as acts committed with intent to destroy, in whole or in part, a national, ethical, racial or religious group. South Africa filed its 184-page brief last week, arguing Israel's actions in Gaza are genocidal in character because they're intended to bring about the destruction of a substantial part of the Palestinian national, racial and ethnic group. Israel says those claims are baseless. Well, the full case is likely to take years, but interim emergency measures could be issued within weeks. The court's ruling will be final, but it cannot enforce its decisions. Well, let's talk now to Michael Becker, Assistant Professor of International Human Rights Law at Trinity College Dublin. Michael, good to see you. First of all, what evidence has South Africa presented to support its claims of genocide?
South Africa's evidence really is made up of two different parts. So on the one hand, South Africa is going to be pointing to the on-the-ground evidence. So this includes the evidence of the widespread killing of civilians, evidence that suggests indiscriminate or reckless bombing campaigns, and also the widespread destruction of housing, crucial, critical infrastructure, indeed the very infrastructure that's necessary to sustain basic life. So we have the on-the-ground evidence of what's happening in Gaza, and that's going to be paired with this evidence that is really coming from Israeli officials themselves. So South Africa is going to point to statements made at the highest levels of the Israeli government and the Israeli military apparatus that, in South Africa's view, provide direct evidence of genocidal intent. Statements that seem to conflate Hamas with the Palestinian people of Gaza as a whole.
Just talk us through the timeline, if you would. What's expected and how quickly could we hear any sort of ruling?
So as your correspondent mentioned, a ruling on the merits of this case, so the ultimate claim that Israel is in breach of its obligations under the Genocide Convention, that will take years. This is the start of a very long process. But the hearings this week are about a kind of emergency relief, provisional measures that can be put in place, essentially to try to safeguard the lives of Palestinians while the case is pending. I would expect the court to move very quickly on this, and we should see a decision, I would estimate, within 2 to 3 weeks.
Just to be absolutely clear, this is not a criminal trial. The ICJ will deliver only an opinion on the genocide allegation. But how significant is this?
You're right. It's not a criminal proceeding. That's for the International Criminal Court to take up. But a final judgment from the International Court of Justice is a binding, authoritative legal statement. States take decisions by the ICJ very seriously, and the ICJ is a critical actor in defining what international law means and how it works. So the way this case is ultimately decided is going to say an awful lot about what the Genocide Convention actually means and whether it has any real practical application in the modern world.
And of all the countries to drive this through, why South Africa? Why is South Africa bringing this case?
Well, the Genocide Convention is a very special kind of international instrument because it is understood to promote a collective interest, an interest that all states that are parties to that treaty share, preventing and punishing the crime of genocide. And so any number of states could have brought this case against Israel. For various reasons, the political will exists within South Africa to do that. South Africa historically has been a very strong supporter of the Palestinian cause, and South Africa, of course, has its own experience with apartheid. And South Africa has pointed to that as being one of the factors that has motivated its decision to intervene in this way.
What's at stake, do you think, for the ICJ and its reputation here?
It's certainly the case that as the ICJ gets drawn into what are highly political disputes in many respects, that creates certain risks for the court. But ultimately, this is a court of law. The ICJ is going to approach the questions put to it from a legal perspective. They're going to draw upon the canons of treaty interpretation. They're going to draw upon their own case law. This isn't the first time that the Genocide Convention has come in front of the International Court of Justice. And they are going to do the best that they can to sort through conflicting factual claims and conflicting legal arguments. So ultimately, I don't think, for example, as some have argued, I don't think the fact that at the end of the day, states might not comply with what the ICJ says, or not everyone will necessarily agree with how the ICJ interprets these instruments, that's a reason not to make use of this international court that sits at the very center of the international legal order.
Michael, I'm sure we'll talk more in the coming weeks, but for the moment, thank you. Michael Becker, Assistant Professor of International Human Rights Law at Trinity College in Dublin.